It's the Here We Go Rapid Review. Just listen to this while you're exercising or driving. You can look at the slides later if you want, or never. We're headed into excuse, avoidance, and risk of loss. Here we go.
Let's move on to excuse and avoidance. We have a deal, we made a deal, we figured out what the terms of the deal, now I want to get out of the deal. Excuse and avoidance. First, unconscionability. Unconscionability. People are stuck with bad bargains. The UCC wants deals to happen. It wants commerce to happen. It wants freedom of contract. What's got to give, and a lot of that is some people are going to get screwed. And the UCC would rather some of that happen than not have as many deals and as much freedom of contract as it could have. Unconscionability is meant to be rare as a defense. If you're going to succeed on an unconscionability claim, generally, and differs by court, but generally courts want you to prove both procedural unconscionability and substantive unconscionability. What does that mean? Procedural unconscionability means there was some unfairness or oppression in the making of the deal. There was some absence of meaningful choice. Someone was kind of bamboozled or put at a disadvantage. There might have been a language barrier. High pressure salesperson barging in on someone when they couldn't make sense of things. Something in the making of the deal that made it really unfair. And there has to be substantive unconscionability. The terms of the deal are oppressive and unreasonably harsh. If you have both procedural and substantive unconscionability, what can a court do about it? Well, a court can not enforce the contract at all and completely let you out of the deal. Or the court can say, well, you're right, this is totally unfair procedurally and substantively, but we want to keep the deal, so I'll just excise the unconscionable portion. Or the court can do even less. The court can limit the effect of the unconscionable portion. That's unconscionability. Some other means of excuse and avoidance. We're not going to get into these, but I want to tell you that they exist. The common law fraud doctrine for avoiding a contract. The statute of frauds is a way to get out of a contract. The UCC has two provisions dealing with commercial impracticability. 2615 is the general commercial impracticability provision. This applies where there's some unforeseen contingency that makes it impractical for the seller to perform, such as a natural disaster. So last month, you contracted to buy a bunch of plywood to be delivered a month from then. In the interim, a hurricane was cooked up in the Gulf of Mexico, and everyone bought all the plywood for several states around. You'd say, oh, commercial impracticability. Now, if you buy the plywood when the hurricane's on its way and everyone's talking about it on the TV, and then the seller says, oh, there's a hurricane, so I can't get to the plywood. Well, at that point, it's not an unforeseen contingency, so you wouldn't be able to get out of it. That's the general commercial impracticability provision. Then there's also a separate special, what I call a special commercial impracticability provision at 2613. If the particular goods that are identified in the contract are destroyed before risk of loss is passed to the buyer. So you have a contract to buy a particular car, and that car gets hail damage or completely destroyed before the time for you to pick it up. That's the special commercial impracticability provision. And that gives the buyer of taking the goods with a reduction for price to account for the damage, or allows the buyer the option of getting out of the contract altogether. Then, final means of excuse or avoidance to let you know that it exists, frustration of purpose. So this is where the purpose for which the goods were being bought has ceased to be. So if you were purchasing a limousine to use for a big parade and then the parade is canceled, I guess. But good luck. Frustration of purpose is pretty hard to win, and it's meant to be rare, kind of like unconscionability. If you're going to make frustration of purpose work, it really helps if the seller is put in no worse position than they were before the contract. So if you agree to buy something, then your purpose is frustrated, and you call them up and you say, no, I'm not going to buy it. and they haven't pulled in any new inventory because of that, or they haven't passed up any opportunities to sell because of that, then that's a situation where you might be able to win frustration of purpose. That's it for excuse and avoidance. Let's move on to our next big topic area, risk of loss. And I'm only going to tell you a little bit about this because it's very complicated. So, risk of loss, some main principles. If the contract provides for who holds the risk of loss, then the contract controls. So if you agree to buy a car, to pick it up on Thursday, and in the contract you agree that if the car is destroyed between now and Thursday, that you will bear the burden of the risk of loss, then the contract controls. That's easy. Otherwise, if the contract's silent on it, then if the loss is caused by negligence, then the negligent party has to absorb the loss. So if you're going to buy a car, the delivery date's a week from now. In the meantime, the seller got intoxicated and drove 125 miles an hour and wrapped it around a concrete pylon, then yeah, they're going to absorb the loss because they were negligent. This will deal with most of the things in the real world in terms of risk of loss. That rule is easy to employ. Now, if the loss is without fault, so something's destroyed in shipment by an earthquake or a meteorite or a collision with some third-party drunk driver, then the UCC has all these default rules for risk of loss. They are complex. I can tell you as a broad principle, they are mostly designed based on which party is likely to have insurance. It's kind of how they did that when designing these UCC default rules. As a general matter, risk of loss tends to pass with title and possession, which sort of makes sense. That's the extent to which I'm going to talk about it here in the review. But there's some broad principles. Now, let me make you aware of one pitfall. This came to me as a question one time. If the goods cause damage to something or someone, like you contract to buy a large wind turbine, and while it's coming down the interstate, it comes off of the truck bed and destroys someone's house, the UCC has nothing to do with that. That's just a torts question. Okay, it doesn't matter that a good was involved. That's just a torts question. So, where risk of loss, we're talking about the good itself is destroyed, not the good comes off of a truck and destroys something else. Not a UCC question if that happens.